You're watching The Legal Breakdown. Glenn, this is the court hearing that we have been waiting for because the Supreme Court ruled that Abrego Garcia had to be returned to the U.S. That was then kicked down to the federal trial court to facilitate how that would be done. Of course, yesterday we all watched as Donald Trump stood in the Oval Office and effectively defied the Supreme Court order. And so now they're in court today for this hearing. Can you explain what just happened?
Yeah, I think a couple of takeaways from today's hearing. One, Judge Sines scolded and was, I'm going to say, upset with the government, the Department of Justice, because they have done nothing to facilitate the return of Abrego Garcia from that prison in El Salvador. And that seems to squarely violate the court order that she issued to facilitate and effectuate his return, as confirmed by the Supreme Court, which said, yes, you must facilitate, you, Department of Justice, Trump administration, must facilitate his immediate release and arrange for his return to the United States. Now, importantly, Judge Sines said, listen, I'm not talking about contempt right now, but here's what I am doing. I am going to set a 2-week time frame, which I know seems long, but stick with me here, Brian. I'm going to set a 2-week time frame to get expedited discovery. She actually said there will be no business hours over the next 2 weeks because she's trying to accomplish two things. One, she is doing everything she can to try to prod the Trump administration into action to begin to actually facilitate the return of Garcia to the United States. And two, this discovery that she has ordered is designed to see whether the Trump administration has already defied these court orders and should be held in contempt. And then we can talk about, what contempt is designed to accomplish. But she said clearly, we're not there yet. She did say, if I find that you are in contempt, well, then we'll have some things to talk about. I'm paraphrasing it. And let me just say, I am basing everything that we're discussing off some really good reporting by Roger Parloff and Anna Bauer from Lawfare, who were in the courtroom, came out right afterwards. I listened to everything they said about what happened, and I was furiously taking notes. But as of right now, she is trying to hold the government's feet to the fire. She said, I am ordering the plaintiffs to have 4 depositions. They can request 2 more. Deposition is a fancy word for putting somebody under oath, sitting down and grilling them about what steps they have taken to facilitate Garcia's return. Because remember, the court order, as affirmed by the Supreme Court, said you need to report on what steps you've taken, what steps you intend to take. You need to fill in the court regarding what is being done concretely to facilitate his return, together with up to 6 depositions. She said you can have 15 interrogatories. Lawyers always make things sound more complicated than they need to be. Those are written questions that you propound to the other side. And you can have as many as 15 document production requests. So this is a very compressed timeline for this kind of discovery. And I know it sounds like it's going to linger for 2 weeks as Mr. Garcia probably suffers mightily in that prison in El Salvador. But this is where we are presently in this litigation.
So I want to be clear. Just because Trump said something in the Oval Office doesn't make it legally binding. So it sounds like the judge is still moving forward under this pretense that the administration has the opportunity to show her if and how it's facilitating this guy's return, despite the fact that Trump has already come out publicly and said that he's not going to abide by the Supreme Court ruling. Is that correct?
Yeah, Brian, you're exactly right. And in fact, the Department of Justice filed another declaration today in which it was supposed to be telling the judge concretely what steps they have taken to facilitate.
Probably a pretty quick read, huh?
Yeah, and what steps they will take. And you know what they said? And this, I think, was insulting and laughable. They said, well, you know what, Judge? We are willing to accept or take control and custody of Mr. Garcia if, get ready for it, he presents himself to a port of entry into the United States. In other words,
so all he has to do is figure out a way to escape from a high security prison and then go to a port of entry to the U.S.
Exactly. And you know what the judge said in response to that? That's not facilitating anything. And in fact, here's what she said about that very Oval Office discussion between El Salvador El Salvadoran President Bukele and Donald Trump. She said, okay, first of all, you, the DOJ lawyers, and the person submitting this declaration reference that conversation. She said, first, that's not evidence before me. And second, I see that the president of El Salvador said, oh, I can't smuggle Mr. Garcia into the United States. And Judge Sines followed up with, it doesn't sound like you're facilitating anything if that's the position of the president of El Salvador. So listen, these DOJ lawyers have nowhere to go because they have no damn case to show they're complying with the order to facilitate his release and return.
Glenn, you mentioned that the judge, Sines, in this case, said that the noting the conversation that occurred in the Oval Office wasn't evidence before her in her courtroom because, again, it took place in the Oval Office. But if it's included in a sworn affidavit and presented to the court, does it then become the position of the DOJ because now those words are being taken from the Oval Office into the courtroom?
Yeah, you know, the declaration is interesting because that really is the only thing of substance in the declaration itself. It's very short, and the declarant, the person who filled it out, said, in essence, we will remove obstacles and we will take him into custody if he presents himself at a port of entry into the United States. Of course, they then added that we will promptly deport him again, but not to El Salvador, to which I say, well, that may ultimately be fine if you give him his constitutional due process rights of notice and opportunity to be heard in court before you deport him. But they add a link in the declaration saying, oh, and by the way, here is where you can find on the internet the conversation between President Bukele and Donald Trump. That's no kind of evidence at all. Yes, right. It becomes kind of part of the atmospherics, and the judge threw it right back in their face, but it really doesn't constitute evidence that the judge will use to decide whether the government thus far is in contempt for intentionally defying her orders and the order of the Supreme Court.
What does contempt look like in this case? Because I know whatever answer you're going to give is going to feel unsatisfactory and small to me, because the reality is that we have a unanimous Supreme Court ruling, and then you have the president, the head of the executive branch, defying that court ruling and plunging us into a constitutional crisis, effectively broadcasting that he is a dictator and therefore not bound by a system of checks and balances that has constituted our system of government for 200 plus years. And so for me to even ask what does contempt look like, I know whatever answer you're going to give is not going to feel satisfactory, but it's still worth discussing because right now this is the recourse that we're looking at.
The most extreme form of contempt might give you a little bit of satisfaction, but I'll get to that in a minute. Civil contempt, which I think is more frequently used when there is any kind of a contempt in play, a violation of a court order. Civil contempt is designed to punish people either financially by making them pay fines for violating court orders, or imposing fines that can sort of add up over time to encourage somebody, compel somebody to come into compliance with court orders. But if we move to criminal contempt, which requires due process, notice and opportunity to be heard, which is one reason a judge can't, like in the movies, just bang her gavel and say, I'm holding you in contempt, right, off to the hooskow. That's not the way it works. There is a process involved before a judge can hold somebody in criminal contempt. But Brian, criminal contempt can look like ordering somebody jailed, detained, to either serve a designated period of time for intentionally violating court orders, or it can be sort of open-ended. I will hold you in contempt. I will order you confined until you purge the contempt. In other words, until you do the thing that you are still being ordered to do. You know, now that rarely happens in the context of the judiciary trying to compel the federal government to do something or prohibit the federal government from doing something. But listen, both gloves have to be taken off at this point, and all lawful vehicles need to be employed in order to make right what is so horribly wrong, violating the Constitution, the due process rights of Mr. Garcia, not to mention others, because if you let this slide, then our slide into autocracy will just continue.
Well, look, you and I have spoken quite a bit, especially in the lead up to the 2024 election, where Donald Trump himself was facing all of these criminal prosecutions. And in large part, not every judge, it seemed like, had the stomach to really go full bore against him. And so I'm wondering, in your estimation, whether you think Judge Sines understands the gravity. Well, clearly she understands the gravity. I don't want to sound condescending here, but the gravity of the moment we're in, the constitutional crisis that Trump is ushering in, and is ready to move forward, to your exact point, with both gloves off, and really give adequate reciprocation in terms of what Trump is doing. Again, he's ushering in a constitutional crisis, defying a unanimous Supreme Court ruling, and so it just feels like unless she goes big, it's going to feel inadequate. It's not going to feel like we're meeting the moment with the urgency that this moment requires.
Yeah, Brian, I don't know much about Judge Sines, but what I have read about how she has been conducting these hearings and how she's been trying to hold the government's feet to the fire, it seems like not only Judge Sines, but it seems like the federal judiciary writ large. I would also point to Judge Boasberg, who is involved in litigation concerning the 200 to 300 other immigrants who were unlawfully, unconstitutionally deported and put in that same terrorist prison in El Salvador. It really does seem like the federal judiciary is trying to meet the urgency of the moment. Let me give you one minor example of why I say that with respect to Judge Sines. I'm going to look at my notes because I was furiously taking notes about what happened in the courtroom. At one point, when she said, y'all are going to be on a tight 2-week time frame and there are no business hours here, and she set out the discovery schedule. At that point, the DOJ lawyer, a guy named Ensign is his last name, said, well, Judge, if you're going to order this kind of discovery on this compressed schedule, will you please issue a stay so we can consider appealing what you are doing? And she said, no. SCOTUS, Supreme Court, has spoken, and there's nothing to appeal here. The issue becomes, did the government, the Trump administration, intentionally defy both her court order and the Supreme Court order?
So it seems at this point, the response from the Trump administration is either going to be compliance or a refusal to comply, in which case the matter is resolved because he's been returned, or we go into contempt proceedings. Is that correct?
I think that's right. And I do think Judge Sines, every step of the way is going to do what she can to keep the pressure on the Trump administration to comply. So this is really, there are parallel tracks here. Try to get them to comply, to make right what they did so horribly wrong to Mr. Garcia, and move forward in the discovery to see whether they should be held in contempt for violating the court order in the first instance.
All right, well, obviously things are moving really quickly and evolving quite rapidly. So for everybody who's watching right now, if you want to follow along, as soon as we get any updates, please make sure to subscribe. The links to both of our channels are right here on the screen. That's also the best way to support our work more broadly. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.